My name's Lucy O'Brien. I'm a postdoctoral fellow in the Melbourne Centre for Commercial Law, and I'm very, very pleased to introduce our speaker this evening, Professor Lauren E. Willis. Lauren is a Professor of Law and Centennial Chair of Consumer Law at Loyola Marymount University in Los Angeles. She's held visiting appointments at Harvard, Cornell, and the University of Pennsylvania. She's a leading critic of the use of financial education, disclosures, and nudges for regulating consumer transactions. Lauren's developed a groundbreaking outcomes-based approach to consumer law. And this approach unites the interests of firms with consumers and retail investors and enables regulators to keep pace with rapid marketplace change. Most recently, she's identified how law must evolve to address businesses' use of artificial intelligence to design and target online communications. Before she came to academia, Lauren worked in the Civil Rights Division of the US Department of Justice and with the US Federal Trade Commission. She co-founded the Consumer Law Scholars Conference and was an advisor to the American Law Institute's Consumer Contracts Restatement Project. Lauren's visiting the University of Melbourne as a 2025 Fulbright Scholar, and her current project follows on from her work with the Australian Securities and Investments Commission to develop the design and distribution obligations. And as I'm sure many of you know, these obligations require financial firms to design and distribute financial products that meet their customers' objectives, financial situation, and needs. And we're very, very lucky to have Lauren here at Melbourne Law School while she completes this important research. And some of you may have been fortunate enough to attend Lauren's Alan Hope Southey Memorial Lecture in November 2023, entitled Deception by Design. That lecture was recorded, as this seminar will be, and it is available on the MLS website if you didn't manage to attend that one in person. This evening, Lauren will speak on the subject, Performance-Based Fencing In, Consumer Law Lessons for Competition Law. Thank you very much, Lauren.
All of you for coming out on a cold and I hear in between, exams and classes kind of day. I forget what you called it again. Watch back. Sounds terrible, but anyhow, thank you for coming out. So what are we going to talk about today? First, we're going to talk a little bit about why consumer law remedies often fail. And we'll go through a few examples of consumer law remedies that have not been terribly effective and understand why. And then draw from that some lessons for competition remedies and look at a few specific remedies that the ACCC is considering at the moment. So why do information remedies, which is one type of consumer remedy, disclosure, information remedies, why do they fail? First, it's because consumers don't respond the way we expect them to. So here are all examples of information remedies in consumer law. There was an attempt in the US to get people to pay less interest on their credit card statements by telling them how much it would take for them to pay each month to pay off the balance in 3 years instead of paying it off in 10. And unfortunately, though, that really didn't end up having a positive effect. Some people actually started paying less per month after they received this disclosure. Conflict of interest disclosures. We find that they often backfire, that people actually trust advisors more after they receive that disclosure. And then on the right is an example from here in Australia. Apparently on your energy bills, you have to receive a disclosure telling you that you could get a better deal elsewhere. It appears to be a universally ignored little item. What else happens with information remedies? Well, firms outmaneuver them. Sometimes this is called malicious compliance. I think evasive compliance is perhaps a better term. It's not necessarily purposeful. But firms do end up hiding mandated disclosures. It can be in fine print or on the second page that no one gets to, behind a maze of clicks. They can use all sorts of visual tricks, and that word right there is tiny if you can't read it. The last word there is blue. As it turns out, as our eyes age, we are less able to see the color blue. So that's a convenient way to make sure people who are older don't read your disclosure. We use ancillary distractions, the salesperson chatting with us as they give us our disclosure causes us to pay no mind to it whatsoever. Or we wait and give the disclosure to people after exhaustion has set in, our commitment already to the transaction. So in the US, we've also tried some choice architecture remedies. The overdraft default in the United States. Congress thought that there was a problem with people overdrafting their checking accounts and paying enormous sums of money, particularly people who were relatively poor. And so they changed the default. So the default became that there would be no fee for overdrafting if you were at an ATM or if you were engaged in just a single debit transaction. And they even foresaw that there might be some evasive compliance and added some rules to this that consumers had to affirmatively opt out. They couldn't be opted out of this default in the fine print. The banks couldn't provide better terms to consumers who agreed to take overdraft. And the banks had to disclose the fees for overdraft. Well, the overdraft default failed. So about a little more than half of new accounts opted out, and essentially all the people who'd been using overdraft fairly heavily opted out of this default. Since that occurred, the CFPB, which essentially no longer appears to exist in the US, did pass a new rule limiting overdraft fees, but Congress just got rid of that limit. So why did the choice architecture remedy fail? Well, once again, consumers responded in unexpected ways. So the majority of people who opted out didn't know that they had agreed to pay overdraft. My babysitter did not understand what she had done when I quizzed her about it. In addition, banks outmaneuvered the remedy. So here is a screen that you would see when you go into your online banking account. But if you had not yet opted out of the default and agreed to overdraft, you would get this pop-up. And it would appear over and over again every time you tried to log into online banking, unless you agreed that you would pay overdraft fees. Banks also sent all sorts of messaging to people to make people feel like it would be scary not to agree to overdraft, or safer if they agreed to it. And they also tried to limit people's experience in the default. So they gave people this deadline, which was completely artificial, saying you had to make this choice so that people would not experience what it would be like not to have an ability to overdraft. Switching cost remedies. Why does this one not work out? Well, the UK banking experience is instructive here. The current account switching service was put in place partly to deal with the loyalty penalty more than just as a competition kind of thing. And they made it so that it would be totally free to switch to a new bank, and the transfer would be automatic of all your recurring payments, all your recurring deposits, easy peasy, keep your same bank account number, etc. But it failed. Why did it fail? Well, consumers, again, responded in ways people weren't expecting. People said that they were afraid of switching, that they were afraid there'd be some sort of security breach in the process, or that one of their recurring payments wouldn't happen. People said that they didn't want the hassle of having to go into the bank and ask them to switch, although they could in fact do it online. And people also said they had no way to tell whether another bank would be any better than their current bank. They hadn't experienced another bank. Banks also spent a fair amount of effort outmaneuvering the remedy. They imposed 12 screens between the consumer and being able to actually fully switch. There were requirements that the consumer keep logging in over and over, some scare messages, caveats about, well, we'll try to do this all within 7 days, even though they were legally required to. Regulator had to get in and really micromanage the process here. And so the idea seemed like a great one, but it didn't work out. So in the tech space, which is the space I'm going to talk about mostly with regards to competition, you can really see how these problems, these consumers reacting in ways that are not expected and in diverse ways, and the ability of firms to maneuver around various legal rules sabotages the attempt of the regulation or of the remedy. And online, it's easier for this to happen, or it's more likely that this will happen. And why is that? Well, first, a regulator, when they go in and think of a new rule for something to happen online, the regulator understands all the technology. Many people don't know what the difference is between a browser and a search engine. And so technology is not transparent to people. People don't understand what it is that the regulator is trying to get them to do. And things change really quickly. It's hard for people to keep up. There's no brick and mortar you have to change, right? Online, a few lines of code, and you can change how something appears or operates. Firms also online, I say they reflexively outmaneuver remedies, like they do it without even thinking, because they're so accustomed to optimize clicks, to optimize various results that they want, and they can exploit user habits and control the context very specifically, figure out just the right tactics to outmaneuver remedies. So here's a few examples. When you see a pop-up screen, what do? Well, the habit of most users is to just hit the X. So forget that disclosure. Lots of little things that are different in different contexts can make a big difference. And so this is from an experiment that looked at different weight indicators and the effect on consumers. So if you make your weight indicator red, at least in the United States, it makes people anxious and they stop waiting. They feel like it's a long time has passed and they give up on waiting. If you make it blue, people are a little more relaxed and they're more likely to wait while something loads. It turns out actually that in Taiwan, the color didn't make a difference. Then another aspect here is this sort of weight indicator. On the one side, you have different pictures of something that's coming up that slowly fills the bar. In the middle, you can't tell from this picture because this is a screenshot, but it's basically a dot circling around. And then on the far side, there's a progress bar. And it turns out that when people saw the first two, they were more impatient. They couldn't figure out how long they were going to have to wait, and they just gave up. And people were much more likely to stick with it if you had the third type. And they've done different tests of all different kinds of weight indicators. They find gender effects of different designs, et cetera. But it's these little things that can make actually a big difference in how the consumer interacts with the online architecture. They can experiment very easily online, right? You can just, it's like an experimental machine, right? You can experiment at scale and find fairly subtle but quite effective tactics. So this was the screen that Apple threw up that you'd have to navigate through for going outside of Apple Pay. to pay for an app or to pay for things associated with an app. This was something that the court had required in California when Epic Games sued Apple for not allowing people to pay Epic Games directly. Apple did a bunch of other things, but one of the things they did was they put up on the screen, it says this app doesn't support the App Store's private and secure payment system. Well, it's a true fact, right? It's not that scary, and yet it was very effective at scaring people away. And all of these tactics can be personalized and contextualized. I think the example people know best is the Netflix example. That Netflix looks different for everyone because they incorporate all sorts of different information about your past behavior and experiment until they find what is most effective in getting you to watch more Netflix. You end up with all these different types of ads that everyone gets a different one, right? Depending on who you are or previews. And this is my little multi-armed bandit. This is the way in which technologically people can actually play around with different experimental conditions online, interacting with different consumer characteristics, user characteristics to figure out what's going to work best. So how should we improve these consumer-facing remedies? Well, there are a bunch of suggestions that have been particularly advocated by the Competition and Markets Authority in the UK, although they have been echoed by the ACCC here. But each of these, I think, is unlikely to be very effective. Not that they wouldn't have some effect, but I don't think they're going to be terribly effective. So ask consumers what the barriers are that they face to shopping and switching instead of just assuming you know. Well, when you ask people things, they have very limited ability to predict their own behavior, to understand exactly why they did things in a changed environment or why they would do something, what they would do in a different environment. You could lab test remedies, but of course there's an external validity problem. People are actually paying attention in the lab. They're not simultaneously doing something else. And the real world context is much more dynamic. You could test remedies in field trials, but truly dominant firms can outweight field trials. And you could audit your remedies after you put them in place and redo them as needed. Certainly that makes sense, but the speed at which a regulator can do that is slow, right? There's just not a way for regulators to act all that quickly. Now, the ACCC has suggested that to deal with competition, remedies should be put into a code that's developed by the ACC with industry. And that part of the reason that they suggested that rather than having it in legislation is that it can adapt more quickly than Parliament can get around to doing something. Although, to be clear, Congress in the US is much worse than Parliament at getting around to things. But even here, Parliament would take a while to get around to things. But firms can change things on a dime, right? You just can't revise things as quickly through a legal process as firms can change tactics. So, having seen this in the consumer law space, I have suggested elsewhere that one thing we might do is set in various kinds of outcomes or performance requirements. It's sort of modeled on emissions standards that rather than telling a firm how they have to make their widget, what technology they have to use, instead we just measure what comes out of the tailpipe or the smokestack, and then they need to meet certain limits, and they can figure out how to get there themselves. So how we improve consumer-facing remedies, that idea that I just described of using performance-based approaches is keyed to what the actual issues are, that consumers respond in unexpected and diverse ways, and that firms engage in evasive compliance. Because it's a remedy that incentivizes firms to actually get to the endpoint you want, your performance goal that you want. It's not that you're telling the firm, hand them the disclosure. Instead, it would be something like, here, we're going to random sample test your customers and see if they understand the key facts about this transaction that they just engaged in. And you're responsible for making sure that they did. And so then firms can use whatever creative ways they want, innovative ways, changing ways, personalized ways to achieve that outcome. So how does that translate here to the competition arena? The idea would be to set competition benchmarks that demonstrate that the firm is meaningfully complying with whatever the prohibition or the requirement is, the particular conduct remedy that's been imposed. Then you give firms flexibility, the ability to try all sorts of things themselves to get to those benchmarks. And then there has to be some sort of incentive system in place so that they actually meet the benchmarks. So to be clear, this is just one possibility for competition remedies. You can have structural remedies. You can have disgorgement remedies. I'm focusing right here just on conduct remedies because that's what the ACCC is focused on and what the UK and Europe are focused on. And all I'm adding here is some performance-based fencing in, really to prevent evasive compliance and to get firms to keep up with diverse consumer reactions. So how do we do this? We set a fair competition benchmark. We give firms the ability to meet the benchmark however they want, and we incentivize it. So for step one, let's look at one example, interoperability remedies. So the ACCC has proposed, and apparently Parliament has agreed in principle, although my understanding is because the session of Parliament lapsed, this process has to be reopened. But to the idea of prohibiting contractual or technological impediments to interoperability, meaning like you can use somebody else's watch with your phone, say. They interoperate. It doesn't have to be an Apple Watch to use an Apple phone or an Android watch to use or a Google Watch to use an Android phone. And you provide access to the hardware and software needed to interoperate. Well, that makes sense to do that. The problem is there are lots of little things firms could do to throw a wrench in that, things that are barely perceptible. They could just make it take longer, be a little more frustrating to use the other parties, the third parties' watch, for example. So the idea of a performance-based fencing in aspect to this remedy would be something like a requirement of functional parity, that the user in experiencing a first-party product or service, that experience has to be no worse than the user's experience of the third-party service, product, whatever it may be. So it could be physical products like watches, could be using somebody else's app store, could be using somebody else's wallet on your phone, things like this. And so how would this be demonstrated? Well, there'd have to be surveys that show that consumers find the key functionalities to work equally well on the dominant firm's option and the competitors, and that dominant firm records show that the amount of time you have to wait, the number of clicks, the cost to the consumer, this kind of thing is equivalent as between the competitor product or service and the dominant firm one. Another example, switching remedies. So the ACCC has proposed to prohibit conduct that frustrates consumer switching, and they specifically have referenced scare screens, and permit communication about alternatives so that if you're a a party that wants to give people access to an alternative product, the dominant firm can't prevent you contractually from communicating with consumers about that. So again, the concern is that firms will evade this, or that consumers might not respond exactly as expected. And so switching cost parity would be a performance-based way of fencing in this remedy. So again, a similar idea, dominant firm records have to show that consumers spend no more time or effort to switch to a non-dominant service. And that consumers believe that the cost, time, and difficulty and dangers of switching are low or very low, like on some kind of Likert scale, perhaps. Because consumer beliefs about how difficult it will be to switch, we saw in the current account switching service problem, really can make a big difference. So another one is to prohibit self-preferencing. So the ACCC has suggested prohibiting anti-competitive pre-installation of various apps and search engines and this sort of thing, browsers, and to get rid of the ability of firms to have default agreements, like, for example, Google's agreement with Apple, that Apple will manage to get manage to put Google in as the default on their Safari browser, the default search engine, in exchange for enough money to, in that particular case, deter Apple from developing its own search engine. So here, frictional equivalency would be a performance-based way of fencing in evasive compliance. So consumers don't find it any more difficult to put in as a default the competitor service rather than the dominant firms, and the actual time spent is no longer, the number of screens, et cetera. It's no more difficult to use the competitor's product or make it the default. Another selection barrier remedy that has been proposed by the ACCC is choice screens. Now, choice screens are one of those things that everybody wants to work. They really want it to work. But you need some kind of, potentially some kind of performance-based fencing in to make it work. Although there might be better ways to do this. But if you wanted to stick with the conduct remedy, you wanted to stick with a choice screen, one possibility is that you would require that dominant firm records show consumers spend no more time or effort to select the non-dominant service than the dominant service. And that surveys show consumers believe that it's very low cost, easy to select the non-dominant service. So choice screens. We know now that the 2009 Microsoft Internet Explorer choice screen was not effective. At the time, people thought it was effective because a lot of people did switch to Chrome. But when people went back and looked at the data, the number of people switching to Chrome during the time period in which Microsoft was required to show the choice screen was the same in jurisdictions where Microsoft was not showing the choice screen. And there was actually a 14-month breach when Microsoft forgot to show the choice screen. I don't know how it took 14 months before anybody noticed, but I think it's because it wasn't making any difference at all. The 2019 Google search engine. There, the choice screen also seems to have not been effective. Now, there was some evasive compliance that we know about. So they had this sort of method of auctioning off spots on the choice screen that led to a result that very poor quality providers would end up the ones that would win those auctions. And the auction was to get then to get you put on the screen, but you only had to pay if you were selected. And so what it led to was basically a list that included Google and then 4 that you'd never heard of before or again. And so of course nobody picked these ones no one had ever heard of. Now they did change the auction mechanics to make it such that actually Bing and Firefox and Opera, search engines people have heard of started showing up. One issue appeared to have been consumer confusion. People who knew they already had a search engine on their phone weren't sure why they were being asked to choose again. But a biggie was most likely brand familiarity. Because when you gave people the choice screen when they first turned on their phone, when they first got a phone, people were more likely to select something other than Google. When you interrupted what they were doing to show them the choice screen, so when they went into the Play Store, obviously, if you go into the Play Store, you're going there for a reason. You want to go download something. And if you show them the choice screen then, people just want to clear it as fast as possible, and they are going to automatically pick the search engine they already know. Now, it is true that Google has a better index, better click and query data, better what we call tail results. So if you do a search and you're looking for something fairly obscure, you're more likely to get it on Google, right? Because for all these years, they've been paying for the default position. They've amassed this huge user base. They have so much money, they've indexed much more than anybody else can have indexed. On the other hand, most search needs are very basic. Most people are searching for the same things, right? There just aren't that many tail search requests. And experiments have been done where people were randomized into different search engines. And consumers on the whole, even if they had been using Google before, when they were randomized into Bing, Yahoo, or DuckDuckGo, tended to stick with those new search engines. Because for the most part, people are just looking for a good enough search experience. They're not looking for something obscure. And part of the reason they didn't try one of these others is because their experience has all been with Google. That's what they've heard of. So these are some reasons why the choice screens haven't worked. And some reasons why we might think, though, that it wouldn't be so bad for people to use some other search engines. So here's the 2024. This is the Google version. There's obviously also an Apple version. Apple's been through a few iterations with the EU because they did play around with a few things that made it clear that there was some evasive compliance going on. Now I can look at this one and tell you there are some issues with the way it's designed, right? For one thing, there's too many choices. People are going to say, I can't go through all this whole thing, figure it out, right? You got to scroll down, et cetera. And it's noticeable that they say Google Chrome, but they don't say Mozilla Firefox. Now, why is that? It's because Google is a better brand name than Chrome is, but Mozilla is a better brand name than Firefox is. So it's these little things they're doing, right? And that's for setting your browser, then setting your search engine. My mom, by the way, if she saw this, would be just like completely confused because she can't figure out the difference between a browser and a search engine. But so she would just click Google because she's heard of it before, right? Or maybe Microsoft. She's a little older, so she might just hit Microsoft. And so I can see that there might be problems. But until we actually test it, we don't really know how consumers are going to react because people react in unexpected ways. I can tell you what I would do and what my mom would do, but I can't really tell you how people would react. But we do know from prior experience that people tend to pick automatically the one they've heard of before, they've used before, it's safe. In some of the other research I'm doing here in Australia, I've been told that there is this sort of sense, maybe that's a little stronger in Australia, that there's safety in numbers, that if, oh, everybody's using this one, I should just use this one, that'll be safer. But one way to combat this would be to make sure that it takes no more time for someone to pick an alternative other than Google than it takes to pick Google. And Google would have to make sure that happens. Well, what would happen if we did that? Google would have to either bury itself at the bottom of the list or not appear there at all. It doesn't mean you couldn't install Google. You could still go out on the web and do it the same way you used to have to do to get DuckDuckGo. And you still do in the US. But realistically, that's going to be the kind of thing you'll have to do to break this brand familiarity advantage that has been worked up over years and years. Now, I'm not saying this is the best way to do it, right? This is the middle one, conduct, remedy, plus some kind of performance-based fencing in here. I would say the selection experience parity. It might make more sense to require them to spin off the advantage service, or, make them actually give up, disgorge, basically, this position that they have. And so instead of saying, no, Google, you can't buy the default position anymore, instead say, okay, you can keep buying the default position, but not for you. You have to start buying it for your competitors instead, so that effectively people will get defaulted into a broader variety of browsers and experience that it works perfectly fine for most people's searches. So the 3 steps again: set the benchmarks, then give them the firm's responsibility and flexibility to achieve them, incentivize this. We spent all that time just on number 1. Number 2, we'll go through just quickly. The firms can do whatever they want, right? They could do all sorts of things in order to meet the benchmarks. They could play with the weight indicators. They could play with the flows. If the idea is that the frictions have to be the same for a competitor product and for the dominant product, well then you could get rid of the frictions between the consumer and the competitor product. The other thing you could do, though, is you could increase the friction for getting to your product. If you're going to put up an extra screen that someone has to tab through to get to the competitor's product, put up an extra screen to tab through to get to your product, too. You could effectively communicate that it's actually easy to switch. Games, visuals, the whole marketing department. And firms could personalize their approaches for different consumers and experiment over time to figure out what works best. Then, of course, you have to give folks incentives to actually do this. The regulator would need to set up not so much just a committee to, with industry, figure out what the code is, but a technical arm, right, that actually has the in-house expertise to conduct random sample consumer surveys, to actually audit consumer journeys and audit firm records. Then the regulation has to incentivize that people really do it. Maybe deterrent level fines, that's what they're trying to do in Europe. That's what the ACCC has suggested here. Maybe a structural remedy should be what happens to you if you can't meet the benchmarks. I fear fines may not be enough when we're dealing with these companies that are making so much money. And we'll see. So performance-based fencing in remedies deal directly with the 2 main problems that we have in consumer-facing remedies in consumer law as well, that they respond in unexpected ways. Well, a court or regulator trying to draft and redraft detailed conduct rules, it's just not going to work because consumers react in ways that are not expected, and firms are going to be much better at quickly adapting and personalizing experiences. And firms outmaneuver remedies. Well, this changes the incentive here, changes the incentive for the firm to actually, the dominant firm to get to the point where they're engaging in competitive behavior instead of evasive compliance. So sorry, that was quite long, longer than I expected. I haven't given this talk before.
I'd like to thank you very much, Lauren, for that extraordinarily lively and engaging presentation. It didn't feel long to me. I don't know about you. Yeah, thank you very much. It's been a really wonderful presentation. You're an incredible presenter and communicator of complex ideas in a very engaging way. So thank you. Okay, thank you all for coming. Good night.